Do I need a court order to change my name? Have you recently gone through a divorce and are wondering about changing your name? This is a common question, and the answer can vary based on your situation and where you live. Let's break it down. If you want to go back to your maiden name or a former name after your divorce, many states allow you to do this during the divorce process. You can request this name change as part of your divorce proceedings. If the judge agrees, they can include the name change in the final divorce decree. This means you do not need a separate court order for the name change. The divorce decree itself serves as your legal document for the name change. You can then use this decree to update your identification and records without any extra steps. However, if you are looking to change your name to something entirely different after your divorce, the process is a bit different. In this case, you will typically need to file a separate petition for a court-ordered name change. This involves submitting an application to the court and possibly attending a hearing. After the court reviews your request, they will issue a court order specifically for your new name. Here are some practical steps to follow. First, if your divorce decree includes your name change, make sure to obtain a certified copy of it. You will need this document for updating your identification. If your divorce decree does not cover your name change, or if you want a new name unrelated to your previous names, you will need to start a separate name change case in court. Once the court approves your name change, it is important to get certified copies of the court order. You will need these copies to update your Social Security records, driver's license, passport, and other legal documents. When it comes to changing a child's last name after a divorce, this usually requires the consent of both parents or a court order. If the other parent does not agree to the name change, you may need to demonstrate to the court that the change is in the child's best interest. In summary, you do not always need a separate court order to change your name after divorce if you are simply going back to a former name and your divorce decree includes that change. For any other name changes, or if your divorce decree does not address your name change, you will need to obtain a court order through a formal name change process. This ensures that your new name is legally recognized and can be updated across all official records.